Chapter 7, Competency and Impeachment. Under the federal rules of evidence, we only have two competency rules. The first one is personal knowledge. By personal knowledge, we mean if a person wants to testify in a case about a particular event, the person must have personal knowledge about that event. Meaning is the person must have a personal knowledge about what he's about to testify. This requirement is very reasonable because if a person does not have the first-hand knowledge as to what happened in a case, the person certainly is not competent to testify. The requirement is this. A witness may only testify as to what he witnessed. He cannot testify as to what he heard or imagined. We understand if when we discussed this hearsay evidence, we already indicated at this point, a person may only testify as to what he personally witnessed. The person cannot testify as to what he heard from another person, because if a person would go to court to testify as to what he heard from another person, that would be hearsay evidence. So in this, under these competency rules, we actually also require this personal knowledge. So if a person would go to court to testify, if a person intends to go to court to testify as to what he heard from another person, the person not only is not competent to testify, his testimony actually would also be hearsay. So in this context, we should understand if a person wants to testify about something, the person must have this personal knowledge about the event he's going to testify. The second requirement, the second competency rule is oath. If a person wants to testify at trial, the person must be willing and able to take an oath to testify truthfully. If a person is unwilling to take the oath, the person is not competent to testify. But of course, not only the person is required to be willing to take an oath, the person must also be able to take an oath. If a person suffers from some mental illness, and then the person would not be able to understand the meaning of the oath, in that kind of situation, of course, the person is also not competent to testify. As to the form of this oath, there is no very strict requirement as to what kind of oath the person must take. Usually in court, we would have this traditional oath. That means if a person goes to court to testify, and then a court clerk would ask the person to take this traditional oath. That meaning is the person would testify. The person will tell the truth and whole truth and nothing but the truth, and so help you God. And then the witness would say, I do. But this traditional oath, it is not really required. The person has to take this oath. If a person says, I'm not a Christian, so I'm not going to take an oath by putting my hand on a Bible. So if that is the case, the person could also take this affirmation, could also fulfill this oath requirement by making an affirmation. By affirmation, we simply mean that is a person's solemn undertaking to tell the truth. That can be in any form. If the person would say, just by my own honor, I promise I would tell the truth, that would also be acceptable. So there is no very strict requirement as to what form this oath has to take, so long as the person would make this commitment, would undertake this obligation to testify truthfully, and then the court would be considered the person to have fulfilled this oath-taking requirement. Then we discuss this issue of this related to impeachment. Before we discuss this impeachment, and then it is important we make a distinction between this competence and impeachment. Competence, that means whether a witness is qualified to testify. That is a decision made by the judge. Before trial, if the person's, if there's a potential witness competence is called into question, there would be a pretrial competence hearing. So the judge will determine whether the witness is competent to testify. But if, say, the judge made this determination, the witness is competent to testify, but not necessarily the witness would be a truthful witness. Not necessarily the person would testify truthfully. So at trial, the person's credibility, the credibility of this witness can be attacked. And then if a party is going to attack the credibility of a witness, and then that is what we mean by impeachment. By impeachment, we simply mean that is an attack on a witness' credibility. We have 5 methods of impeachment. And we will discuss these 5 methods of impeachment. The first one is impeachment by prior inconsistent statements. If a witness testifies in court, but if that is learned, the person actually made a prior inconsistent statement, and then the other party could use this prior inconsistent statement to impeach the witness or to attack this witness' credibility. Let's look at this example. Suppose we have this Sam is on trial for assaulting Tom, and he claims self-defense. But we know if to be successful in claiming this self-defense, the defendant must establish he was not the first aggressor. If the defendant was the first aggressor, of course, this self-defense would not be available. So Sam asks Charlie to testify for him. Charlie says Tom was the first aggressor. So if indeed Tom was the first aggressor, and then Sam could claim self-defense. But the prosecution learns Charlie actually made a prior statement to the police. Over there, Charlie said to the police, Sam started the fight. So apparently in this case, this Charlie actually made a prior inconsistent statement. He testifies, he says one thing, at trial, he actually stated a different thing previously. So in this kind of situation, the prosecution may offer Charlie's prior inconsistent statement to impeach him or to attack his credibility. That is what we mean by impeachment by prior inconsistent statements. The second impeachment method is impeachment by sensory or mental defects. So this can be many different ways. And if, for example, if a person testifies in court stating that he overheard this conversation in a very crowded and noisy restaurant, if the other party learns and this witness actually is suffering from this hearing loss, and then, of course, this party could bring up this evidence as impeachment evidence to impeach this person. Meaning is you have this problem of this hearing problem, and how could you claim you actually heard this conversation in a crowded and noisy restaurant? So that is what we mean by this impeachment by sensory or mental defects. Or indeed, if a person is nearsighted, but the person claims that she actually saw a crime that committed quite some distance away from her, and this nearsightedness could also be brought in as impeachment evidence. Of course, if a person suffers from a mental illness, and then if the person testifies, the other party could also bring up these mental defects, and then the impeachment party could say the person is suffering from this, having these mental defects, and the person is not possible for the person to perceive things or remember things correctly, so the person's testimony would not be reliable, and then the jury should not really take this testimony seriously. So that is what we mean by this impeachment by these sensory or mental defects. The third method of impeachment is impeachment for bias. If the witness has a bias for or against someone, this bias could be used as impeachment evidence. This bias can be in many different ways. If we look at these examples, and we would have a sense what we mean by this impeachment for bias. Suppose the husband is on trial for a crime, and then the wife would come forward to testify for the husband. And then, of course, we know this prosecution can actually point out the relationship between this witness and the defendant, because a wife apparently would have this bias. Possibly the wife would have this bias for the husband. So we just want the jury to be aware this possible bias. And then in the second example, suppose we have this police officer and who goes to court to testify to identify an African American defendant as the perpetrator of a crime. And if the defense attorney learns this police officer in the past made racial remarks, this defense attorney actually could bring in this evidence to impeach this police officer. Meaning is the defense attorney could say this police officer is had this bias against this African Americans in general, so his testimony against this particular defendant may not be reliable because of this police officer's bias. So that is another example of this impeachment for bias. And then the last example, suppose we have this Adam and Bill. They were both involved in this insider trading scheme. But now Adam is on trial for this insider trading. Bill now testifies for the prosecution against Adam. But why Bill would testify for the prosecution? Because he entered a plea deal with the prosecution. So if that is the case, the defense attorney could bring up this plea deal as impeachment evidence. The defense attorney could argue because Bill has made this plea deal with the prosecution, so that's why it is likely he would testify for the prosecution, and then he would blame everything on Adam, so that he himself could get this lighter sentence. So because of this situation, Bill's testimony may not be 100% reliable, so the jury should be aware of that. So that is another example to demonstrate what we mean by this impeachment for bias.